Misconceptions surrounding Cook Islands Trust. Located about 2,000 miles from New Zealand and 3,000 miles from Hawaii, the Cook Islands may seem like they're in the middle of nowhere, but when it comes to asset protection, they're right at the center of the conversation. High net worth individuals and savvy trust attorneys have long relied on Cook Islands Trust as powerful legal tools for protecting wealth. But like many offshore financial vehicles, they've also been the target of numerous rumors and myths. This video takes on misconceptions about Cook Islands Trust head-on, clearing up confusion around ethical and regulatory concerns and providing smart strategies for making legal use of these trusts. Debunking common myths about Cook Islands Trust. Let's dive right into some of the biggest myths about Cook Islands Trust. Number 1, lack of oversight. I'm asked several times per day, how do I know I can trust my foreign trustee? Your Cook Islands trustee is not just some guy sipping piña coladas on a remote beach. Rather, these trust companies are actually better supervised than US-based trust companies, which is why over the last 30 years, the Cook Islands have built a reputation as a go-to destination for financial protection. Highly reputable trust companies here follow strict procedures to ensure their clients' assets are safe and protected. Myth 2, offshore trusts facilitate illegal activities. Just like a car can be used for illegal purposes, so can an offshore trust. However, the idea that offshore trusts are primarily used for illegal purposes is complete malarkey. Cook Islands trusts are among the most respected in the world when it comes to legal safeguards. The Cook Islands have implemented rigorous regulations including anti-money laundering and countering the financing of terrorism measures to ensure that their financial system isn't used for illegal activities. Myth number 3, tax evasion loophole. Let's be clear, Cook Islands trusts are not tax evasion tools. The Cook Islands work closely with international authorities to prevent tax evasion, and US citizens who use these trusts are still required to report them to the IRS. Failure to do so can result in serious penalties. However, reporting your trust to the IRS and FinCEN does not compromise protection, nor does it increase your tax liability or chances of being audited. Are Cook Islands trusts invincible? While no legal tool can be considered invincible, Cook Islands trusts have a nearly perfect record of protecting assets. These trusts have some strong advantages, including refusing to recognize foreign judgments and providing confidentiality, clearing up trustee responsibilities. One common misconception about Cook Islands Trust is that these trusts have total control over your assets. In reality, you retain significant powers, such as directing investment and requesting distributions. Trustees are bound by strict legal requirements and must always act in the trust's best interest, following the rules laid out in the trust document. Risk management and wealth preservation. Now that we've dispelled some myths, let's talk about the real benefits of Cook Islands Trust. They offer top-notch protection against lawsuits, divorce, and other creditors. These trusts can safeguard a wide range of assets from cash, stocks, bonds, real estate, cryptocurrency, and various other assets. In addition, these trusts pass wealth to your heirs without the hassle of probate. Unlike the long, public, and often costly probate process in the US, Cook Islands Trust allow you to streamline the transfer of your assets privately and efficiently. However, if your only concern is avoiding probate and you are not concerned about protecting your assets from lawsuits, there may be other tools which are more appropriate for you. Professional guidance makes a difference. Offshore trust law is complex, and there's no exception to this in the Cook Islands. That's why it's crucial to work with experienced legal and financial professionals. An experienced asset protection attorney can help you select the best jurisdiction to register your trust, choose the right offshore banking partners, structure your trust correctly, and ensure you're compliant with all relevant regulations, including those from the IRS. Typically, legal issues with Cook Islands Trust only arise when they aren't structured properly. By designating separate roles for the trustee, settler, and protector, you avoid conflicts of interest and ensure everything runs smoothly. Your attorney can guide you through this process. The importance of ethical conduct. Cook Islands Trust have strict ethical guidelines. The country has enacted strong regulations, including background checks for trustees and insurance policies to protect clients from loss or negligence. These safeguards ensure that trusts are used responsibly and legally, promoting transparency and international cooperation. The Cook Islands have taken significant steps to align themselves with international regulations. Since the International Trust Act was passed back in 1984, it has been updated several times to reflect evolving global standards. This shows the Cook Islands' commitment to creating a trustworthy and cooperative environment for wealth protection. Education and awareness. The best way to combat misconceptions about Cook Islands trusts is through education. These trusts have a strong reputation for integrity, privacy, and security, making them a solid choice for those seeking to protect their wealth. If you're considering setting up a Cook Islands trust, consulting with an experienced offshore law firm is essential to ensure everything is above board and set up properly. For more information or professional guidance on setting up an offshore trust, contact Blake Harris Law today.